so for my case, my final presentation, I wanted to do the famous versus infamous and defamation cases, and basically this is just a different title for the private versus public in defamation cases over time. So first, I want to do an overview. I'm going to talk about, address the Gertz versus Robert Welch of 1974 and the matter of Cohen versus Google of 2009. And so some basic terms that I want to describe, and then I'll briefly describe again at the end. So defamation, there are two forms of defamation, and it's libel is the written publication, and this is the publication of false or malicious statements that damage someone's reputation. And then slander is just the oral form of damaging someone's reputation. So I really want to talk next about New York Times Co. versus Sullivan decision of 1964. And this applies to actual malice. And this is a huge case that I'll address more as I talk about another case later on. So actual malice in regards to the New York Times Co. versus Sullivan is a condition that exists when a person makes a statement with either knowledge of its falsity or reckless intent or disregard for the truth. So if in a defamation suit with a public person, figure, it has to be made with actual malice in order to be liable for claims. So prior to the New York Times case, it was just defamation as the standards. So you had to, something, people would say something and then you could appeal it to the fact that it was in falsity of representing you as a public official and it damaged your reputation, and that's what you had to prove. But then after the New York Times case, it goes into actual malice, and further, you had to go further with public people and defining public officials, and these public officials had a harder time to prove defamation because of actual malice. And they had to prove that the person who posted or said things about them did it knowingly and did it with reckless intent. So this all applies to what I want to do, because I want to be a media blogger for sports and then hopefully a sports journalist. So obviously I need to be careful about what I say and what I can say on the media and what is okay for me to say. So furthermore, this all addresses the First Amendment and freedom of speech clause. So basically, I just want to say overall, because of this decision in New York Times, it's hard, very, very hard for public officials to win a defamation case. So going further on, this cartoon applies to the Robert Welch versus Gertz case that I'm going to talk about and discuss. And this kind of just informs you about the media and what does the media want? Does the media really want facts, or what do they want? And it talks about mainstream media just sucking those things in, or do they suck them out? And it just says, what do they want this time? The usual. So I thought it was a fun little cartoon to get us started to address my next topics. So this is the case that I'm first going to talk about, and it's Gertz versus Welch, Robert Welch of 1974. And I'm going to give you a little background because right here is just the basic information. So Robert Welch Incorporation is the owner of American Opinion. It's a magazine, and Gertz is just a lawyer. So the case actually began when a police shot and killed a kid, Nelson, and the Nelson family wanted to sue for wrongful death damage charges, and so they hired Gertz as their attorney. But while all this trial was happening, the corporation published an article to the trial about the trial and said that this trial was a frame-up and basically was all made up and it was Conman's fronter. And so they accused the Nelson trial in this manner, and then of course they degraded the attorney Gertz as well. So Gertz sued Welch for defamation claims, and furthermore, he was denied by the New York Times. He was denied because the New York Times versus Co. Sullivan ruling that I talked about, actual malice, because these the first two courts appealed to Gertz as a public official. And so the reason why they did this is because Gertz actually was involved in the coroner investigation. He went to go witness it, but he did it as his job only. But the Gertz appealed and said that he was a person of public interest and of public knowledge because he was in the coroner investigation and a part of that. But truly, Gertz was just doing his job as a lawyer and just defending the Nelson family. So this further went to the Supreme Court, and the issue that was brought is a person who's not a public figure or official protected from libel under the First Amendment. So Justice Powell actually ruled in favor of Gertz, a majority 5-4, and appealed that the New York Times versus New York Times Co. versus Sullivan is not applicable, and Gertz is ruled as a private individual. And so this actually, I actually want to go further into this and apply that the ruling applies to the fact that the public have higher standards, and this is what Welch was trying to appeal to Gertz as a public official and slap the actual malice clause on him, and so therefore he wouldn't have the defamation claims. But since he was clarified as a private individual, he has more protection, and public officials don't have that because they are already putting themselves in a public light, so therefore they're willingly putting themselves out there, but Gertz was not, and this was damaging his reputation, obviously. So this, I just wanted to quote something from Powell. It says, on defining public officials, that's a key point for this case, public versus private, and it's those who occupy positions of such pervasive power and influence that they are defined of public figures. So this, as a key point, adds on to the New York Times versus Sullivan case, and it defines what a public official is, and also defines private versus public, and the fact that private deserve more protection because they're not putting themselves out there. So it also just puts a checks and balance on the media and applies to the First Amendment, where it does say they can say, First Amendment says freedom of speech, but they can't say whatever they want in regards to hurting other people. So it creates a checks and balances. So then this actually brings me into the next case that I'm going to discuss, and I have a little video here that I'm just going to play a few minutes of.
On August 21st, 2008, the blogger made 5 separate postings on the website blogger.com entitled Skanks in NYC. Including captions and photographs Cohen found not only defamatory, but hurtful. Words like skanky, hoe, and
Okay, so that's just a little background on it. So basically, Cohen was a New York fashion supermodel, and she was ridiculed by a blogger that was obviously a part and found on Google, and it was called Shanks of NYC. And she argued that Google had to give the name of the actual blogger because she wanted to sue for defamation, because these claims that the blogger was making about her were obviously in appealed to a defamation claim, but she was denied by the district court and then denied by the appellate court, and then it went to the New York Supreme Court, and then this is where they ruled in favor of Cohen. So Cohen actually got the name released. So this is a huge case because Google had to open up privacy and obviously not go against the First Amendment, but this bloggers was not protected by the First Amendment because the issue is, should the host of the website have to disclose the identity of an anonymous source if they publish a defamatory statement? And the answer is yes, because media sources cannot post whatever they want, and they can't just hide behind a computer screen. And because this ultimately was damaging her reputation as a supermodel and causing damage for her career, and obviously the words were sexually promiscuous, and these were displaying facts, and because the pictures were of her and then displaying content of what she is or defining her, and this was hurting her reputation. Excuse me. And then any regular viewer could apply these words to Cohen as a model or as a person. So they did qualify for defamatory statement, and majority opinion of Madden of the Justice Supreme Court was the fact that these are not just opinion statements, but they are actually they're hurting this supermodel and her reputation, and therefore the reputation was given up by Google. So this is a huge privacy debate in obviously regards to the defamation in the First Amendment, and due to defamation, the identity of this blogger was given up. So further on, Cohen got the identity, and she actually settled with the blogger outside of court because the blogger attorney knew that they weren't going to win. But the blogger actually said they took down the site, but they also clarified that there was no malintent. But at the end of the day, the blogger said that this was against the First Amendment and their First Amendment, because they should have been protected under the First Amendment for their opinions. But like I said, these weren't just opinions and hyperbole statements, but they were defamatory, and they were, like I said, they fall under defamation factors, and they damage reputation. And basically, these are false descriptions and portraying this model in a false light, and ultimately damaging her career. So this addresses facts versus opinion, and the fact that although this blogger could argue that they were giving their opinion, you can't just say whatever you want in regards to the privacy of another individual and damaging another reputation and damaging, causing damage and putting someone in a false invasion of, or a false light for other people to see, because obviously this is a well-known blogger, and people looking at this can correspond that to her. So it talks also about disclosure and disclosing information, and this information, you can't just hide behind a media screen and disclose information about whoever you want, because at the end of the day, if someone wants to find you, they can find you for what you have wrongfully said. And these claims of defamation, if it would have gone to trial and the blogger wouldn't have settled, they would have been tried for defamation, and Cohen, it would have been in favor of Cohen, because they were defamatory statements, and they lied under the defamation factors. So this also addresses the new media that we live in, so like the social media context we live in. People trying to say whatever they want, and you really can't do that with private versus public officials, because if you're damaging and putting someone in a false light intentionally, because you just either don't like them, or you're just being degrading of individuals, especially private individuals, you will get in trouble, and your First Amendment will not protect you versus the privacy of a private person. So just comparison, libel versus slander, as we talked about in the beginning, and then defamation, the factors that appeal to defamation, and the factors are just elements of cause of action for defamation of a false statement or published without privilege or authorization of the third party, constituting fault as judged by, at minimum, a negligent standard, and it must either cause special harm or constitute defamation per se. So that's for private individuals, and then added on is actual malice that we got from the New York Times versus Sullivan case for public individuals. So that's an argument against. And then we talked about the factors that apply to defamatory and then actual malice. And then the questions that I just have for you to wrap this all up is, do you believe that private individuals should be able to protect themselves from the media? Now that you've listened to these cases and you've seen examples of private individuals claiming for defamation, and then even a public figure like the model claiming for defamation, and actually if she went forth with it, she would have won the claims. But do you believe that public figures are able to, or should be able to, protect themselves against the media? And especially in this day and age, do you think public figures should have more protection? And then I'd like to know, how would you feel if the media posted something about you that wasn't true, like in the light of Cohen, and posted something about you in a false light? And just coming off that, have you ever felt violated by what people or the media has said about you? So it's just something to think about. And then furthermore, here is my works cited.